Welcome to Liberty Nation's 5 Facts. President Donald Trump's second nomination to the United States Supreme Court is most definitely viewed as something of a game changer, to use a fashionable cliché. Democrats are whipping up a fair amount of fear concerning the issue of abortion rights to justify their opposition to Brett Kavanaugh's nomination. I'm Graham Noble, here to set the record straight with 5 facts you may want to pass on to your leftist friends about abortion and the Supreme Court. Fact number 1. The Supreme Court will overturn Roe v. Wade only by ruling on a future case that compels it to utterly reject the court's original opinion. The court does not simply choose to re-litigate settled cases. The decision in favour of Norma McCorvey, A.K.A. Jane Roe, was far more nuanced than simply declaring that she had the right to abort her pregnancy. In fact, the case became more about the right to privacy than about abortion itself. In reality, and despite whatever future restrictions the Supreme Court may permit states to place upon abortion, it is extremely unlikely that this decision will ever be conclusively overturned. Fact number 2. Even if we were to indulge the hypothetical future scenario in which Roe v. Wade is overturned, the status of abortion rights in 46 states would not immediately change in any way. If Roe v. Wade were overturned, abortion simply goes back to the individual states for legislation. Roe v. Wade effectively prevents states from completely banning abortion, so any state that decided to preserve a woman's right to get an abortion could still do so. Fact number 3. Roe v. Wade isn't the definitive or final word on the legality of abortion. There is no all or nothing argument here. That majority opinion in favour of one woman in one state certainly did not erase all restrictions on abortion. More than half the states in the US do not allow abortions after certain periods of pregnancy. Most of those states ban it after 20 weeks or after 24 weeks. Almost all other states attach various conditions to getting an abortion. Counselling, waiting periods, or parental consent for those under 18 are all common requirements. Fact number 4. The real fight over abortion rights has always been at the state level. The pro-life movement understands that fighting abortion at the state level is more productive than attempting the monumental task of overturning Roe v. Wade. Those states most likely to see concerted efforts to ban all abortions already restrict the procedure considerably, and pro-life politicians in those states may find it hard to argue that the many restrictions already in place do not go far enough. This makes the hysteria on the left about Roe and the High Court all the more unrealistic, which brings us to our 5th and final point. Fact number 5. Roe v. Wade is safe, barring a fundamental shift in American thinking toward a majority consensus that abortion is equivalent to murder. Even then, a nationwide ban on abortion would have to go through legislation in Congress, and not just come straight from the judicial branch. The judicial branch does not write or amend laws. That authority lies only with the legislative branch. The hysteria over Trump's ability to tilt the Supreme Court is really about ideology. Where conservatives prefer justices adhere to the Constitution, the progressive left wants justices who will interpret the Constitution in favour of the progressive worldview. Whatever one's personal views on abortion, unless Americans as a nation come to view it as a violent crime, it will never be completely banned at the federal level. These are 5 important facts that demonstrate that the fight against Brett Kavanaugh is not a fight to protect safe and legal abortion in America. For LibertyNation.com, I'm Graham Noble.